NICN/OW/01/2018 between Mrs. Ijoma Lucy Abajo and another, and Michael Opera University of Agriculture, Mudike.
The parties in court?
I can see the accounts, my lord. Thank you, my
lord.
Yes, please.
Yeah, my lord. With all due respect, my lord, I am A.D. Asiegu.
Yes.
Lord, I hold the brief of Emma Okebu.
Yes.
Yeah, my lord, humble appearances for the defendant.
Yes, is the claimant in court? Claimant? Court clerk, can you confirm if the claimant was served?
Yes, my lord.
Yes, Mr. Asiegbo.
Yes, my lord. The matter before my lord today is for adoption of written address of councils, my lord. And the defend.
Yes.
Yes, my lord. The written submissions of the defendant in this matter, my lord, is dated 15th day of March 2022.
Yes.
And filed same day, my lord. Yes.
Yeah.
Yes, my lord. Upon receipt of the claimant written address, the defendant filed their reply on point of law. Lord, the reply is dated the 16th day of May 2022 and filed on 20th May 2022. My lord,
Yes.
my lord, we adopt our written submissions in this suit as our argument.
Yes.
In urging my lord to dismiss this suit. Fight against the defendant. My lord, the suit is competent. Constitutes an abuse of court processes.
Yeah.
We urge my lord, to dismiss the said suit with substantive cost. May you please, my lord.
What about the claimant's written address?
Yes, my lord, the claimant written address, my lord, we go by the rules, will adopt, it will be deemed as, let us adopt their processes. The claimant address is dated the it's dated the 6th day of May. The claimant's address is dated the 6th day of May and filed 10th day of May.
6th day of May 2022.
Yes, 2022. Yes, my lord. So sorry, my lord.
And filed when?
And filed 10th May 2022.
All right.
Yes, my lord, will deem their processes as properly defined. So.
Any more?
No, my lord. No, my lord. That's all we have for this matter. Don't have. No, my lord, that's the matter for today, just for the adoption of the council's, both council's addresses.
All right. All right. I have a judgment which I believe is ready to be delivered. So instead of taking another date, I'll just proceed to deliver it so as to shorten the time
Ask God, places.
for completing the proceedings.
My lord, so sorry, my lord.
Yes.
Okay, go ahead. So sorry. So sorry, my lord. It's okay, my lord. I'm sorry. Sorry.
What's your application or
No,
observation?
I
Observation
withdrew. No, my lord, I withdrew.
All right. That's okay. Just a minute. Let me confirm one or two things here.
Ask God, places.
All right. Judgment. You may mute your microphones until I'm done. According to these claimants' writ of complaint, which was filed on the 3rd of January 2018, they are aggrieved that the defendants indefinitely suspended their employments unlawfully without recourse to their individual conditions of services, regulating their respective employments in the institution. They jointly believe that inter alia that their individual employments, which were offered them on the same date, that is the 17th of November 2015, initially on temporary basis of 1 year each, were subsequently regularized after they underwent separate regularization interviews scheduled by the defendants. To their astonishment and chagrin, the defendants purportedly issued and served them with letters dated the 28th of June 2017, which surreptitiously suspended their otherwise permanent employments after about 15 months of working in the first defendant institution. Failing their effective recall or reinstatement, these claimants jointly came to the refuge of this court for redress for what they perceived to be a wrongful and an illegal suspension of their individual employments. The claimants' joint complaints and accompanying processes were originally filed on the 3rd of January 2018, as stated already. In their statements of facts, they jointly seek for the following reliefs against the defendants. 1, a declaration that the statutory procedure or process allowed by the laws / regulations, including the revised conditions of service for senior staff 2015, as it affected the claimants, were lawfully or legally followed in the suspension, were not lawfully or legally followed in the suspension of the claimants, as there was no provision at all for the suspension of a temporary appointment in the extant laws / conditions of service for senior staff of the first defendant. 2, a declaration that the suspension of the claimant's temporary appointment by the defendants after 16 months after they attended and passed their regularization interviews on the 17th of February 2016 is unlawful, wrongful, illegal, and of no effect or moment whatsoever. 3, a declaration that the non-issuance of regularization letters to the claimants after 16 months prior to the suspension of their temporary appointment was a default or mistake of the defendants, which cannot be visited on the claimants, neither should the claimants be punished for same. 4, an order mandating the defendants to further issue and hand over to the claimants their respective regularization of appointment letters, consequent upon the regularization interview held on the 17th of February 2016, which interview the claimants passed and the defendants are reluctant or has refused, failed, and or neglected to release the results and their respective regularization letters to date. 5, a declaration that the withholding of and non-payment of the salaries and other allowances, stroke emoluments in the claimants by the defendants, despite their being captured fully in the 2016 budget and the 2017 budget proposals and estimates, is wrongful, unlawful, illegal, unconstitutional, and of no effect whatsoever. 6, a declaration that the selective suspension of staff on temporary appointment, inclusive of the claimants by the defendants, and the issuance of fresh temporary appointment letters to new persons to occupy the positions of the staff on suspension by the defendants is a clear case of victimization, vendetta, and a derogation from the claimant's fundamental human rights, as the actions of the defendants is whimsical, unlawful, illegal, and highly reprehensible and condemnable. 7, an order mandating the defendants to immediately reinstate the claimants to their status or positions stroke offices in the employment of the first defendant with full financial benefits with effect from the 30th of June 2017, when the wrongful suspension letter took effect. And finally, 8, general and exemplary damages of 5 million naira only against the defendants jointly and or severally. These claimants also jointly filed a reply and an additional statement on oath deposed to by the first claimant on the 20th of September 2018 out of time. With the leave of this court, however, it was regularized via the claimant's application dated the 15th of July 2018, but filed on the 20th of September 2018, long before they opened their case. The claimants opened their case on the 16th of May 2019, adopting and relying on their written testimonies on oath as witnesses, that is CW1 and CW2. They tendered a total of 28 documents in this suit, admitted and marked as exhibits C1 to C28 sequentially. They eventually closed their case on the 20th of October 2020, after they were duly cross-examined by the opponent's counsel. Meanwhile, the defendants filed their joint memorandum of appearance, statements of defense, and accompanying processes against the suit of the claimants on the 11th of June 2018. These processes were, though filed out of time, duly regularized by their application to this court dated the 31st of March 2018, but filed on the 11th of June 2018. Eventually, the defendants opened and concluded their own case on the same 22nd of February 2022 by calling and relying on the testimony and evidence of a sole witness, DW1, one Agbai Moses. He was duly cross-examined on the same day by the claimant's counsel, whereupon the defendant's counsel closed their case on their behalf. At the conclusion of trial, the parties were ordered to file their respective final addresses, consequent upon which the defendant's counsel filed his on the 16th of March 2022. The claimant's counsel filed his final written arguments and submissions on the 10th of May 2022. In accordance with the rules of this court, the defendant's counsel again filed and served a written reply on points of law on the 20th of May, 2022. It was, however, not until the 6th of March, 2023, that is today, that counsel for the defendants was able to adopt the arguments and submissions on behalf of all the parties in this suit, whereupon this court delivered this judgment immediately. Now, allow me to go straight to the decision part to save more time.
Scott, please.
All right. Court's decision. Having perused the entire processes filed by the parties, evaluated all their evidence, and considered all the legal opinions and submissions of learned counsel for the parties, I also agreed to adopt the same issues raised by the counsel to resolve this dispute. As such, the two issues for determination are: one, whether from facts and evidence available before this court, this suit is incompetent; two, whether the claimants have discharged the minimum standard of proof to be entitled to the reliefs sought in this suit. On issue number one, this issue seeks to resolve the question whether this suit is incompetent. I recollect that at the inception of their defense to this action, the defendants filed a motion challenging the jurisdiction of this court to hear and determine this suit. The said motion was stayed in view of the need to make progress in the substantive suit and in anticipation of ultimately answering and resolving the issue of jurisdiction at the stage of judgment by this court. This is in line with the court's policy to adjudicate matters timeously. Learned counsel for the defendants justifiably resurrected the irresistible questions within his final written submissions and arguments, which are that whether this suit is incompetent because these claimants allegedly failed to exhaust all internal dispute mechanisms of settlement within the varsity before approaching this court in defiance of the acts establishing the institution, and whether or not these claimants ought to have instituted this suit within 3 months of the cause of action arising in accordance with the Public Officers Protection Act. And lastly, whether or not this suit is incompetent for misjoinder of parties, saying that the claimants sued jointly for reliefs in respect of individual contracts of employment. Without stating the obvious, jurisdiction is sacrosanct to every judicial proceedings. The case of Madukolu versus Nkem Dilim, citation supplied, is the locus classicus and it remains fresh in everybody's mind, where it was laid down that for an action to be competent before any court of law, the following conditions must communally exist. One, that the suit must be initiated or commenced with a due process. Two, the subject matter must be within the court's general power to adjudicate. And thirdly, the court must be properly constituted. It is therefore trite that a court labors in vain when it adjudicates without the requisite jurisdiction. This agreeably underscores the need to resolve the question whether the suit of the claimants is incompetent as alleged by the defendants. The first step in determining this issue is to find out how true it is that these claimants never exhausted all internal avenues in the first defendant institution in resolving their grievances before approaching this court. I should state without embellishment that this question should never have arisen in the first place. Why do I say so? It is plain from the parties' pleadings that this fact is no longer an issue. Paragraph 24 of the claimant's statement of facts is worth quoting, since it is averred therein that, and I quote, the claimants state that consequent upon the notifications and protestations of the affected staff or workers of the first defendant, including the claimants, the defendants about the 8th of August 2017 issued a circular or notice to the entire university community with reference number .. of the 11th of August 2017, duly signed by Jacinta N. Ogu, Mrs., the Registrar / Secretary to Council of the University. That letter was titled Council's Decision on Suspension of some Staff on Temporary Appointment and Related Issues, close quotation. The defendant's response to the above is seen in their paragraph 10 of their statement of defense, which reads thus, I quote, the defendants admit paragraph 24 of the statement of material facts, end of quote. Clearly, the defendants already admit the fact that there were notifications and protestations by the claimants as well as other affected members of staff against which the defendants reacted to in a circular published in August 2017. Stating now that these claimants never complained to their employers or that they failed to exhaust all measures for amicable resolution of their disputes is an unhealthy one. Indeed, in the face of unwavering evidence suggesting that the defendants had already made up their minds or taken decisive positions with respect to the claimant's employment status when they suspended their employments. As such, having admitted in their pleadings the course of action taken by them afterwards, there is absolutely no need for further proof to establish that the claimant's options at having the matter quietly and effectively resolved by the varsity's authorities were indeed available to them and open before they chose to come to court. In any event, being in a more superior position as the claimant's employers, there is a saleable probability that the defendants would not have even allowed the claimants the opportunity of having their troubles resolved internally anyway. Meanwhile, there is no doubt that the claimants have an unfettered right, therefore, to institute this action directly in virtue of Section 254C, 1A and K of the 1999 Constitution. As such, that question is resolved against the defendants. Besides, the defendants failed to mention exactly what internal avenues were still explorable by the claimants before resorting to litigation in a court of competent jurisdiction. Mute your microphone, please. Thank you. Section 22(8) of the Federal Universities of Agriculture Act, which was cited and relied upon by counsel for the defendants, does not and cannot salvage the situation when, after all certain facts have been admitted by the defendants in affirmation that the claimants did make certain notifications and protestations concerning the suspensions which yielded no fruits. I therefore resolve this question in favor of these claimants. The next question I would resolve is whether this suit is incompetent for misjoinder. The defendants' counsel submitted that these claimants have separate employment contracts with the first defendant institution. As such, they cannot be a joint action by them. Counsel believes that each of the claimants should have instituted separate actions and then subsequently apply to consolidate them with the leave of this court. I believe that counsel is misguided. I beg your pardon. Is misguided about the rules of this court, since Order 13, Rule 1 of the Rules of this Court 2017 makes clear provisions on joinder of parties in a suit when it provides that, and I quote, all persons may be joined in one action as claimants in whom any right to relief is alleged to exist, whether jointly or severally, and judgment may be given for such claimants as may be found to be entitled to a relief, and for such reliefs as the claimant may be entitled to without any amendments. End of quote. The emphasis, of course, is on whether jointly or severally, as contained in the said rule. Therefore, the contention by the defendant's counsel that the claimants have separate contracts of employment with the first defendant varsity is untenable. Although these claimants have separate contracts of employment with the first defendant, It is undeniable that they were both affected by the singular action of the defendants among other staff of the university. These claimants have similar grievances or reliefs arising from the same cause of action against the same defendants, and it is more efficient and convenient for them, and for this court indeed, to have their grievances prosecuted jointly in the true spirit of the rules of this court. Again, this question is resolved against the defendants. As to whether this suit is statute barred, the Learned Defense Counsel had argued that this suit was commenced outside the limitation period of 3 months allowed in Section 2A of the Public Officers Protection Act. Therefore, this action is statute barred. I am poised to take a critical look at this issue for the simple reason that the rule. Please mute your mic. Thank you. For the simple reason that the law is trite, that any action caught in the web of the provisions of a limitation statute is incompetent, and the court lacks any jurisdiction to entertain same. Should a court entertain such action, the proceedings will be a nullity. For the nature and application of the principle of statute of limitations, it is material to reproduce the pronouncement of the erudite Justice Oputa JSC of blessed memory in Idigbe versus Adefarasin, citation supplied, where he stated as follows, and I quote, "A cause of action is said to be statute barred if in respect of it, the proceedings cannot be brought because the period laid down by the limitation law or act had elapsed." You may see the remaining quotation. Needless to rationalize is the fact that the Public Officers Protection Act was obviously enacted to protect a public officer from disparagement and unnecessary litigation in the course of performing the functions of his office. I, however, believe that it never intended to deprive a party of legal capacity to ventilate his grievance in the face of blunt injustice. Consequently, the Public Officers Protection Statutes do not provide blanket protection for public officers. The law is thus purely designed to protect only the officer who acts in good faith and does not apply to acts done in an abuse of office and without semblance of legal justification. You may see Ofoboche versus Ogoja Local Government Council, etc., including the National Revenue Mobilization, Allocation, and Fiscal Commission and others versus Ajibola Johnson and others, citation supplied. Thus, the Apex Court has recognized certain exceptions to the protection provided for under the law. These exceptions include in A, instances of continuance of damage or injury; B, situations where the public officer acted illegally or outside the scope of his office or outside his statutory or constitutional duty; C, cases of recovery of land; D, breaches of contracts; E, claims for work and labor done; and F, good faith. The law being considered in this particular suit now is the Public Officers Protection Act, which provides under Section 2A as follows, I quote, "Where any action, prosecution, or other proceeding is commenced against any person or any act done in pursuance or execution or intended neglect or default in the execution of any such act, law, duty, or authority, the following provisions shall have effect. A, the action, prosecution, or proceeding shall not lie or be instituted unless it is commenced within 3 months next after the act, neglect, or default complained of." End of quotation. It is now well settled that the provisions of Section 2A of the Public Officers Protection Act applies to both natural and artificial persons. For this, you may see Ibrahim versus Judicial Service Commission of Kaduna State, citation supplied. In the case before this court, these claimants were served with letters of suspension dated the 28th of June 2017 on the 30th of June 2017. Now, paragraph 1 of the claimant's statement of facts states this clearly. Meanwhile, this suit was filed on the 3rd of January 2018, about 6 months after the suspension of the claimant's employment, which is a period well outside the 3 months allowed under Section 2A of the Public Officers Protection Act. Should this court therefore rule that POPA does not apply in this matter and so bar these claimants from enjoying any gains from this action, it should be understood that the position of this court seemed to liberate from one case to another, and of course, depending on the circumstances of a suit, on whether POPA should apply to bar a claimant's claims. In some of my previous rulings, I refused to dismiss a cause simply because the defendant sought to weaponize the defense offered under POPA to disentitle a claimant from his legitimate entitlements. Relying on and following the 2019 decision of the Supreme Court in National Revenue Mobilization, Allocation and Fiscal Commission and others versus Ajibola Johnson and others, Supra, this court's opinion ordinarily would have been that POPA does not apply in cases of contracts of employment. In Ajibola's case, Supra, the respondents were interviewed, issued appointment letters as staff of the National Revenue Mobilization, Allocation and Fiscal Commission. They accepted their letters and reported for work and were even addressed by the Director of Personnel of the first appellant. The respondents continued to report at the headquarters of the first appellant until they were orally asked to stay away from work, as there was accordingly a directive from the then nascent government to place an embargo on and to stop all appointments made in the month of May 1999. Consequent upon the said directive, the first appellant wrote to the respondents withdrawing their appointments. The withdrawal letters were dated the 6th of December 2000. The trial court and the Court of Appeal found that there was a valid contract of service between the parties, and there was no further appeal on this point. The trial court and Court of Appeal also found that the contract was frustrated but not communicated to claimants on time, and so awarded salaries up to the date of the judgment of the trial court, which was affirmed by the Supreme Court. In resolving the question whether POPA applied to bar the respondent's suit against the appellant, which is also the issue relevant here, Ariwola, JSC, now CJN, said at pages 267, paragraph C, page 270 as follows, and I quote, "The second issue is whether the learned justices of the Court of Appeal are right in holding that the appellants do not enjoy the umbrella of Public Officers Protection Law in contracts of service. In this matter, while the appellants maintain that the action is caught by Section 2A of the Public Officers Protection Act, the respondents argue that the act is inapplicable. There is no doubt, a careful reading of the respondent's claim will show clearly that it is one of a contract of employment. It is now settled law that Section 2 of the Public Officers Protection Act does not apply to cases of contracts. I have no slightest difficulty in holding that the appellants are not covered by the provisions of the Public Officers Protection Act as to render the respondent's action statute barred. In sum, I hold that the learned justices of the court below are right in holding that the appellants do not enjoy the umbrella of the Public Officers Protection Law in the contract of service involving the respondents. This issue is accordingly resolved at appellants." End of quotation. This was seemingly the position of the law with respect to this question until the apex court again decided in Michael Idachaba and others versus the University of Agriculture, Makurdi, which is a stated that POPA applied to employment contracts. This prompted the Honorable President of this court, the Honorable Justice B.B. Kanyip, to pronounce in Mr. Victor Omotosho Ekundayo case with suit number citation supplied, which was delivered on the 23rd of February 2022, at page 31, paragraph 126 as follows, and I quote, "There is, however, the wider question whether this action of the claimant is a trajectory of the case authorities on this issue, especially emanating from the apex court of the land. One will see that they have oscillated from holdings that say the limitation law, that is including POPA, does not apply to contracts of service. It should be noted that employment contracts are contracts of service. Then to it applies, and then to it does not apply. And now again, to it applies. The problem here is that except for the Honorable Justice Ariwala's decision in National Revenue Mobilization Allocation and Fiscal Commission case, very little attempt has been made to review the older authorities before arriving at the whether the limitation. In his commentary on the above case, the Honorable President also remarked that the thing, however, with Idachaba and others versus University of Agriculture, Makurdi, and 4 others, is that it did not refer to the older authorities or to even the Honorable Justice Ariwala's categorical holding in the National Revenue Mobilization, Allocation and Fiscal Commission case. This, incidentally, is the scenario in which the constant argument of the Defendant's Counsel that this case is statute barred must be considered. Now faced with 2 conflicting decisions of the apex courts, this court is bound to accept the latest decision as applicable precedence. See Cyril Osakwe versus Federal College of Education, Technical Asaba, and 2 others. Citation provided, where it was pronounced that, and I quote, in the hierarchy of the courts, where there are 2 conflicting judgments of the Supreme Court, the Court of Appeal, indeed, and any lower court for that matter, is bound by the latter or the last decision of the Supreme Court. It has no choice, however brilliant and knowledgeable the justices of the Court of Appeal might think or hold that they are. End of quotation. Although I acknowledge the fact that the Defendant's Counsel never elicited or even contemplated arguments when he wrote this question in his final written address, but it must be appreciated that it would be impractical to make a correct finding without revealing the available conflicting judgments of the apex courts on whether POPA should be invoked to apply in contracts of employment, such as in the instant case, or that the claimants, such as in the instant case. The Claimant's Counsel has his work cut out since he never even bothered to offer any arguments in his scanty final written address in any direction. One obvious fact concerning the nature of the employment relationship between these parties is that the claimant's employment is not statutorily flavored, contrary to the assertion or the impression made especially by their counsel. This is more so since it is one that is temporary and has a fixed duration of 1 year. The implication, of course, is that upon the expiration of the term, the temporary employment relationship ceases or ends even without the necessity of giving the employees any notice, however, be renewed or regularized, whereupon the employee's status then transmutes to one that is probationary, and finally, permanent and pensionable. For all intents and purposes, therefore, the claimants were under a temporary period of 1 year only. Reverting back to the question at hand, which is whether POPA should apply to deny them of their claims, there have been several modest contentions by lawyers that the statutes of limitation do not operate to bar a claim in a purely master-servant relationship. This presumably will still be their position if the master is a public servant under the law. The alternate argument is that POPA only applies with respect to employments that have statutory correlation. This court had the privilege of reading a brilliant ruling made by my brother, Mr. Justice K.D. Damulak of the Akure Division in suit number NICN/AK/03/2021, which is Babalola Akinkumi and 86 others versus VC Ekiti State and 3 others, which was delivered on the 18th of March 2022, where learned counsel appearing before him made the supposition that POPA only applied in employment cases that were statutory in nature. The court rejected that opinion and relied on the Ajibola's case to hold that POPA did not apply in that suit. Back to the instant case, however, by the time these claimants instituted this action, their respective temporary employments with the defendants had already extinguished the law. It did not end there. The claimants waited for 6 months before instituting this action for a redress of their grievances. What constitutes their grievances is seen from the originating writ of complaint, which are inter alia that the statutory provisions or processes allowed by the laws, stroke regulations, including the revised conditions of service for senior staff 2015 as it affected them, were not lawfully or legally followed in their suspension, as there are no provisions at all for the suspension of a temporary appointment in the extant laws stroke conditions of service for senior staff of the first defendants. That the suspension of their temporary appointment after 16 months of attending and passing their regularization interviews on the 17th of February 2016 is unlawful, wrongful, illegal, and of no effect or moment whatsoever. That the non-issuance of regularization letters to the claimants after 16 months prior to the suspension of their temporary appointments was in default or mistake of the defendants, which cannot be visited on the claimants. Neither should the claimants be punished for same. That the withholding of and non-payment of the salaries and all the allowances stroke emoluments of the claimants by the defendants, despite their being captured fully in the 2016 budget and the 2017 budget proposals and estimates, is wrongful, unlawful, illegal, unconstitutional, and of no effect whatsoever, etc. As far as this court can tell, none of these claimants are owed for any work done by them, since there is no such claim for any arrears of salaries, allowances, or perquisites. Having elaborated on the need for the court to adhere strictly to the latest decisions of the Supreme Court on this issue, and indeed found as a fact that in accord with the counsel for the claimants, for the defendants, that this suit was instituted outside the 3-month statutory duration allowed under POPA, this course of action is hereby declared to be a stale one. After all, in all actions, suits, and proceedings at law and in equity, the diligence and careful actor or suitor is favored to the prejudice of he who is careless and slothful, who slips over his rights. The law may therefore deny relief to a party who by his conduct has acquiesced or assented to the infraction of his rights, or has led the opposite party responsible for or guilty of such infraction to believe that he waived or abandoned his rights. You may see INEC versus Ogbadigbo, local governments, and others. It is straight law that when a law stipulates the process of doing or for doing any act, unless it is done in that prescribed way, that act is otherwise illegal. This suit, therefore, is incompetent and dead on arrival, and I so hold. Issue number 1 is hereby resolved against these claimants and in favor of the defendants. I cannot neglect the claimant's Exhibit C7, which is a pre-action notice dated the 26th of August, 2017, which was pleaded in paragraph 25 of their statement of facts, and which was claimed to have been served on these defendants. It needs to be mentioned that the defendants challenged this fact and denied receiving such pre-action notice in paragraph 11 of their statement of defense. There is no further evidence establishing the service of Exhibit C7 on the defendants in view of the denial by the defendants, particularly since there is no endorsement on Exhibit C7 to suggest that it was served and received by the defendants. The claimants nonetheless pleaded in paragraph 26 of their statement of facts a certain delivery slip from Red Star Express Courier being their evidence of proper service of Exhibit C7 on the registrar of the first defendant institution. Unfortunately, this piece of document was not physically tendered in evidence by these claimants, or perhaps not considered relevant enough to positively impact on the claimant's case, For what is worth, however, the claimants failed to discharge the onus on them in proving proper service of the pre-action notices on the defendants. However, since the defendant never made this to be one of their reasons to challenge the court's jurisdiction, this court shall not be bothered to comment further on this. Despite the position taken, this court shall, however, proceed to resolve the remaining issue raised for determination, as it is the tradition of this court to do so, and as ensconced by the Supreme Court in the case of Idigbe versus APC, citation supplied, as well as in Dasuki versus FRN, citation supplied. So issue number 2. This issue seeks to determine whether these claimants discharged the minimal standard of proof for them to be entitled to the reliefs sought in this suit. It is needful to reproduce the reliefs sought by these claimants in this suit for the sake of clarity. Now, there are 8 of them. For sake of time, there will be no need for me to read through. I believe that these reliefs would easily be resolved under one generic question, which is, was it wrongful, unlawful, or illegal for the defendants to have suspended the claimant's temporary employments? It is not in dispute that the claimants were appointed by the first defendants as temporary staff. Exhibits C1 and C14 are the first and second claimants' respective certificates of appointments tendered and admitted in evidence by them. I find paragraphs 1 and 8 salient and worthy of reproduction for purposes of emphasis. Paragraph 1 of Exhibit C1 reads as follows, and I quote, I write on behalf of the Vice Chancellor of Michael Owerri University of Agriculture, Omodike, to offer you a temporary appointment as Executive Officer for 1 year in the instance in the Registry Department. The appointment, which is conditional upon your having been declared medically fit, takes effect from the date you assume duty. End of quote. Meanwhile, paragraph 8 of Exhibit C1 reads thus, and I quote, You will be entitled to 30 days leave on the completion of at least 10 months service. The appointment will terminate after 1 year. It will, however, be renewable subject to satisfaction report on your work. The appointment may be terminated at any time during this period by 1 month's notice in writing on either side. It is plainly obvious that the employments of the claimants in virtue of exhibits C1 and C14 were temporary, transient, fixed, or short-term, and it was meant to remain so, safe, and until they are renewed or regularized by the defendants. But before I delve deeper, it is imperative to note the language of those letters which are exhibits C1 and C14. Much as these parties have variously used the words regularization, however, the word renew was employed on the face of those documents. The letters particularly provide that their employments or appointments, which has been their choice of word all through, are not pensionable safe and until they are regularized or renewed. And in my own mind, using both words, regularize and renew interchangeably, amounts to linguistic nonchalance, because whereas the word regularize means to make a situation that is already existing legal or official, renewal, on the other hand, indicates the act of making a contract valid for another period of time after it extinguished. You may see the Oxford Learner's Dictionary for these differences. It is tried that where words used in a document are plain, the court must restrict itself to their ordinary meanings without any importation thereto. It suffices to state, therefore, that the employments / appointments offered these claimants by the first defendant Varsity in virtue of exhibits C1 and C14 were determinable by a fluxion of time, that is 1 year only, which may or may not be renewed or entered afresh for an additional 1 year, subject to satisfactory reports on the claimant's performances. It is equally obvious that these employments can as well be regularized. Hence, the claimant's temporary contracts of employment supposedly extinguished on the eve of the anniversary of their creation, which is on the anniversary of the date that they formally resumed duty as per exhibits C1 and C14. Unfortunately, the said resumption dates were not made known to this court. However, the claimants averred in paragraph 1 of their statement of facts that they were employed on 17 November 2015. If that is the position, it therefore implies that their respective temporary employments automatically extinguished on the eve of the 16th of November 2016. These parties copiously disputed the issue of the word of regularization of the claimants' employments. The claimants averred that they were invited for regularization interviews, which they purportedly passed, even though no letters of regularization were issued to or served on them. In an attempt to prove that assertion, the claimants tendered exhibits C2 and C24, which are both letters of invitation to interview for regularization of their appointments. The defendants did not dislodge this piece of evidence during trial. The defendants' counsel nonetheless made heavy weather about the admissibility of most of the documents tendered by the claimants, arguing particularly that they were uncertified public documents and thus inadmissible as evidence regardless of the claimant's notice of production given to the defendants. This position by the learned counsel for the defendants is rather misconceived for the simple fact that exhibits C2 and C24 under consideration were tendered in proof of the facts that the claimants received. Please mute your microphone. Mute your microphone. Thank you. This position by the learned counsel for the defendants is rather misconceived for the simple fact that exhibits C2 and C24 under consideration were tendered in proof of the fact that the claimants received those letters of invitations to the said interview. The claimants simply tendered in evidence what they received from the defendants and no more. It is tried that a person who has taken custody of letters served on him is entitled to tender what he received. These letters are therefore not inadmissible, and same were properly admitted in evidence by this court. The question that remains to be resolved is whether the employments of the claimants were regularized or renewed. The claimants sought as one of their reliefs for an order to declare that the non-issuance of letters of regularization of appointment to them is a default or a mistake, and also for this court to order the defendants to issue out letters of regularization of appointment. I believe that to so do would amount to stretching the business of this court beyond the scope, which may result in descending into the arena. Indeed, the court does not act in vacuum. An interview is an administrative examination, and it is usual for the examiner to publish the results of the successful candidates. Additionally, a successful candidate might be issued with a certificate to indicate he passed his interview. So, in order for this court to be able to command the defendants to be issued letters of credence to these claimants, it must have been clearly established that they passed the interview. Unfortunately for the claimants, they could only afford to rely on hearsay evidence that they were told they were successful in their respective interviews by one of the interviewers. They never bothered or failed to call such person into the witness box or to adduce this otherwise vital piece of evidence. I am thus convinced that these claimants' temporary employments were never renewed or regularized by the defendants, as there is no scintilla of evidence establishing this fact. Their assertions are therefore baseless and speculative. Moving forward, it is tried that where there is a controversy on whether an employment is one clothed with statutory flavor or not, the following questions become germane to consider. A, is the employer a body created by statute? B, does a statute or a regulation derived from the statute make express provisions regulating the employment of a staff of the category of the employee in question? For this, you may see Idigbe, Obu versus NNPC and other cases. Now, the apex courts in resolving the same question in the case of Imoloame versus West African Examinations Council, citation supplied, said as follows, I quote, "There is an employment with statutory flavor when the appointment and termination is governed by statutory provisions. It is accepted that where the contract of service is governed by provisions of statute, or where the conditions of service are contained in regulations derived from statutory provisions, they invest the employee with a legal status that is higher than an ordinary one of a master servant. Without ado, the law creating the first defendant varsity is a fact. Creating the first defendant varsity is a fact, and this court must take judicial notice of that. The Federal Universities of Agriculture Act, Cap 22 Laws of the Federal Republic of Nigeria, 2004, is the enabling act creating the first defendants. It is also clear from the claimant's letters of appointment, exhibits C1 and C14, that their employments were subject to the constitution of the university and such conditions governing senior, professional, administrative, and technical appointments. I mentioned before now that the plain and unambiguous language of their letters of employment expressly state that the appointments shall automatically terminate after 1 year. The implication of this is that these temporary appointments held by the claimants were contracted to end by a fluxion of time and without further notice. This court is therefore convinced that after 1 year, that is at most the 17th of November 2017, the claimant's contract of employment expired and came to an end, and I so hold. It goes without saying that their continuous stay in the first defendant's varsity beyond the 17th of November 2017 were at the pleasure and instance of the defendants. Consequently, at the time exhibits C5 and C18, those are the letters of suspension, were issued and served on the claimants by the defendants. There were no longer any statutory obligations whatsoever on the defendants to keep them in their services. The first paragraph of exhibits C5 and C18 is salient as it reads as follows. I quote, "Following the expiration of your temporary appointment, the Governing Council of Michael Owerri University of Agriculture, Mudike, in her 19th emergency meeting held on June 21, 2017, decided that all expired temporary appointments be suspended with effect from June 2017, end of quote. It should be understood in layman terms that having extinguished automatically, their employment relationships became inextant, and so none of them could have claimed and or maintained any legal rights or assumed any liabilities for the order, save for such rights or obligations that existed before the extinction of their contracts of employment. This court already found that the claimants remained at the pleasure of the defendants after the tenures of their temporary employments expired. This finding is certainly undisturbed, even by the fact that the claimants continue to receive pension alerts from their bankers, or that their names appeared on the defendant's staff nominal roll meant for preparing the institution's annual budget for that year, or that they participated in various trainings and programs organized by the first defendants. It should be appreciated that these claimants have the burden to prove their claims. These claimants failed to discharge such burden convincingly. As such, the suit fails in its entirety, and having resolved issues 1 and 2 in favor of the defendants and against the claimants, their reliefs are completely refused and the case is dismissed. Judgment is accordingly entered, and I make no orders as to cost.
As court pleases.
Yes.
As court pleases, my lord. My lord, can you hear me?
Yes, I can hear you.
Hello? Okay, my lord, we are grateful for this wonderful judgment. So research, my lord, is an eye to us. It's a good one. It's an eye opener for us, and we sincerely thank my lordship in this judgment.
All right. Emma, okay, go.
Yes, my lord. Yes, my lord. Emma is out of town. He traveled out for his health medical treatment.
Okay, I hope he's okay.
Yeah, he's getting better, my lord.
A.D. Atiegu or the claimant?
Yes, my lord. Yes, my lord. For the defendant, yes, my defendant, my lord.
Who appears for the claimant?
The claimant, look at their process. One G.O. Abomian Esquire. G.O. Abomian.
G.O.
Agbomian. Yes, my lord.
Agbomian.
Yes. AIGBOMIAN.
For the claimant?
Yeah, for the claimant, my lord.
absent on the dates on the day of judgment?
Yes, my Lord.
I hope you will not be absent on the day of the real judgment.
I believe he will not. He will not.
All right, you'll get a copy of this judgment immediately after proceedings today.
As God pleases. We are grateful, my Lord. We are grateful.
All right, just give me a minute to tidy up, then we go to the next case.
As God pleases.
All right. Yes, please, call the next case.
Okay, my Lord. Suit number NICN/OW/05/2020 between one Honorable Onukafo Okechukwu S, two Honorable Anaba I. Alex Ifeanyi, and three others. And the one Obingwa Local Government Council. Lord, that's the second one. Thank you, my Lord.
Are the parties in court?
Yes, sir. The party are in court.
Hold on just a bit. Yes, please.
Yes, sir, my lord. I'm CM Ukpabio. With me is CD Iroha Esquire.
CM
We
Ukpabio.
jointly appear. Yes, sir, CM Ukpabio.
With who?
With CD.
Spelling?
Iroha.
Feeding. F.
CD.
CD. Iroha.
Yes. Iroha Esquire.
Where is he?
Wait.
Can't see. You see?
She's here.
I can't even see you.
Okay, I'm here, sir.
Your video is muted. Ukpabio.
Ukpabio, sir.
I can't see you.
Yeah.
Okay. Okay, now I can see you.
Okay, sir. Yes, sir. We appear for the claimants.
For the claimants.
Yes, sir.
How many claimants are there?
There are 5 claimants.
5 in number.
5 in number.
Defendants?
Yes.
The defendant present?
Not present.
Simon, can you confirm if he was served?
Yes, my Lord. I was with my registrar when she called the council.
So the proof of service is in the file?
Yes, my Lord. They were called. They were sent messages.
All right.
Thank you.
Yes, Mr. Ukpabio.
Listen, my Lord, the matter is for adoption, sir, of final written address.
Okay.
Yes,
Please, can you give me the spelling of Iroha? I-R...
IROHA, sir.
Okay. Thank you. All right.
Listen.
Okay.
My Lord, the final written address is dated the 26th day of April, 2022.
Yes. Was
and
filed.
filed on the 6th day of May, 2022.
Yes.
My Lord, we adopt same as our final submission in this case. And urge
Yeah.
my Lord to graciously grant the relief or the claim of the claimants in this suit.
Now, are you aware that the defendant was served or not? The defendant.
They were served, sir.
All right. All right. I have a judgment prepared, and I think it is ripe for delivery.
As court please.
Now, in the writ of complaint filed on the 20th of January 2020 against the defendant's local government area, these claimants are aggrieved by what they perceive as a willful refusal or neglect by the defendant to pay their entitlements stroke allowances, including out-of-pocket expenses allegedly owed them during their respective tenures as duly elected councillors in Obingwa, Local Government Council of Abia State, between 2016 to 2018. Having made several entreaties and demands for the release and payment of the state entitlements, stroke allowances owed them, these claimants have now approached this court for the determination of their rights against the defendants. The claimants' complaints and other accompanying processes were filed on the 20th of January 2020, as stated already. In their joint statement of facts, they seek 3 reliefs, which are itemized in the judgment. In response to the claims, the defendant caused to be filed its memorandum of appearance, statement of defense, and accompanying processes against the claimant's suit, all dated the 7th of February 2020, but filed on the 5th of March 2020. Having apparently joined issues, the claimants opened their case on the 18th of March 2021, calling in the testimony of one witness, which is the first claimant. He adopted his sworn deposition and tendered a total of six documents, which were all admitted and marked exhibits C1 to C6, respectively. They eventually concluded and closed their case on the 10th of February 2022. Despite several notices and orders on the defendant to appear on all the days subsequently set aside for its counsel to appear and cross-examine the sole witness who testified for the claimants, the defense neither appeared to participate nor showed any interest to defend this action before the court. Having thus satisfied itself of the defendant's nonchalance in this action, the court accepted the claimant's counsel's application to foreclose the defendant from cross-examining CW1. All other subsequent dates on which the defendant was formally notified and ordered by this court to appear to open its defense were never appropriated. As such, this court again foreclosed the defendant from defending this action and proceeded to order the claimant's counsel to address the court on their claims as presented before this court. Consequently, the claimant's counsel filed his final written arguments and submissions on the 6th of May 2022, pursuant to the rules and order of this court. Proceedings were, however, stalled since June 2022, as this division of the court had to be shut down for security reasons. As such, after the court was reopened in January 2023, the parties were notified and given today for them to appear before this court virtually for the purpose of adopting the claimant's counsel's final written address. Having thus successfully adopted his final written submissions and addresses, this court proceeded to immediately deliver this judgment virtually today. Please permit me to go straight to the decision part. Court's decision. I thoroughly examined all the processes, facts, testimony, evidence, and submissions made in this case. I am satisfied that the centric issue for determination of this suit is whether from facts and evidence available before this court, these claimants have satisfied the required standard of proof to be entitled to the reliefs sought. This issue is analogous to the sole issue raised by the claimant's counsel in his written submissions. The peculiarities and circumstances of this suit make it imperative to make a brief prologue before I delve into the kernel of the issue for determination. From this court's record, it is clear that the defendant was initially duly represented by counsel on the 18th of March 2021, when the CW1 adopted his written statement on oath as his evidence in chief, and also tendered in documents as proof of his claims, of their claims. Upon completion of CW1's examination in chief, the defendant's counsel sought for an adjournment to the 23rd of June 2021 to enable him to cross-examine CW1. His application was graciously granted, and so the case was adjourned to the 23rd of June 2021 for cross-examination of the CW1 by the defendant's counsel. Trial, however, resumed on the 18th of November 2021, but the defendant was not nominally represented or represented by its counsel, despite confirming that they were indeed notified of the new dates. Nonetheless, this court further adjourned the suit to the 10th of February 2022. On that said 10th of February 2022, the defendant was still absent from this trial and remained unrepresented by any counsel. This prompted the claimant's counsel to apply that the defendant's counsel be foreclosed from cross-examining the CW1, which application this court granted, and so the claimants closed their case on that day. The case was again adjourned to the 10th of March 2022 for the defendant to open his own case. This court, however, resumed hearing on this case on the 30th of March 2022, but unsurprisingly, the defendant was still absent and unrepresented by its counsel. This court became satisfied that it had granted sufficient latitude to the defendant to call in evidence in its own defense. The defendant was granted salubricious opportunities of being heard in compliance with the second pillar of the principle of natural justice, which is fair hearing, as entrenched under Section 36, Sub 5 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. These claimants' counsel had moved this court on the 30th of March 2022 to foreclose and strike out the defense of the defendant, which this court found meritorious of grant. By Order 38, Rules 2, Sub 2, 3, and 4 of the rules of this court, of this court 2017, where a cause, sub 2, where a cause is called for hearing and the claimant appears in court, but the defendant or respondent and or counsel who had entered defense was not in court and no good cause has been shown for the absence, the claimant may prove the claim insofar as the burden of proof lies upon the claimant. Sub 3, where a claimant was allowed by the court to prove his claim in the absence of the defendant or respondent and or counsel, the court shall adjourn the case to enable the defendant to appear in court to prove the defense. Sub 4, if on the date fixed for the defendant to appear before the court to prove the defense and the defendant fails or neglects to appear, the claimant may be allowed to file a final address and adjourn the case for adoption of the final address, provided that the defendant shall be put on notice on a date fixed for adoption of the final address. Meanwhile, the defendant's failure to call in evidence to substantiate its averments or pleadings, excuse me, is, to say the least, perilous to its case. It is right that facts are different from evidence, in that evidence is adduced for the substantiation of facts. It then follows that facts to which no evidence is led are deemed to have been abandoned. In our jurisprudence, a litigant is at liberty to front-load witness written depositions on oath for as many witnesses as he deems necessary in proof of his claims. Regardless of the number of written depositions filed, however, a court is only obliged to reckon with those that were adopted by the witnesses as their evidence in the suit. The appellate court nailed this position of law in Kuti versus Alashe, citation supplied, where the Honorable Justice Salami, as he then was, held inter alia as follows. I quote, "The failure of the appellant to produce a shred of evidence in support of his averments to the effect that the members of their Alausa family became Bale Agunfoye after the demise of Dunde is fatal to their case. They are deemed to have abandoned their pleadings. Pleadings are no substitute for evidence, and averments in a pleading not supported by evidence are deemed as abandoned." End of quote. Now, needless to stress is the fact that the failure to adduce evidence or elicit one through cross-examination of the opposing party is a risky game plan, because evidence is the salt of every trial. In the dictum of the Honorable Justice Ungutaji SC, evidence is the medium of proof, and proof is the essence of evidence. In line with these judicial positions, there is no gainsaying here that the defendant chose to waive its pleadings, and so same is rightly deemed abandoned. I must re-emphasize that for the court to believe the witness's deposition, such witness must be called upon physically and put through the furnace of cross-examination by the opposing side. This suit shall hence be decided on the strength of the facts and evidence presented by these claimants only. That notwithstanding, in civil cases, the burden of proving the existence of any legal right or liability which is asserted is on he who wants the court to believe that it truly exists. Sections 131 of the Evidence Act and 132 are apposite. It is rudimentary that in civil proceedings, the burden of proof, those said not to be static, is on the vulnerable party to lead credible evidence in proof of his case. As such, the Evidence Act prescribes that the burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. These judicial and statutory authorities underscore the necessity for the claimants to, as sine qua non, adduce cogent, compelling, and unambiguous evidence to establish their claims in this suit, irrespective of the manifest dearth of evidence on the part of the defendants. A claimant's case might still fail if he has not proven his claims convincingly enough, despite the fact that there was no defense put up by the opposite side. Meanwhile, I have dedicated valuable time to evaluate the evidence adduced by these claimants in their bid to substantiate the reliefs sought in this suit. Beyond the written statement on oath by the first claimant, I discovered that exhibits C1 to C6 speak for themselves as proof of the facts which they intend to prove. It needs to be emphasized that the contents of these exhibits are not only cogent, but are also compelling enough to grant the claims sought. After all, it is trite law that documentary evidence is the hanger upon which oral testimonies are assessed. Having not been dislodged by the defendants, they are deemed credible and reliable in the determination of this suit. Meanwhile, these claimants seek the following reliefs: a sum of 44,306,000 naira being unpaid entitlement stroke allowance and out-of-pocket expenses, OPE, owed them to the claimants as past elected councillors in Obingwa local government council between 2016 to 2018, which the defendant vehemently refused to pay them despite repeated demands made to her, or alternatively, any other sum or amount as may be effectively or properly calculated by the Honorable Court as arising from the said statutory allowance. 2, interest at the rate of 21% per annum on the aforesaid sum from December 2018 to the date of judgment, and 10% monthly interest on the judgment till same is finally liquidated by the defendant. And 3, cost of the suit. The evidence adduced by these claimants remain unassailable, positive, and cogent, and so I am satisfied that their claims should succeed, and I so hold. It is therefore hereby ordered that the defendant shall pay to these 5 claimants the total sum of 44,306,000, being their unpaid entitlements, allowances, and out-of-pocket expenses, OPE, owed to them as past elected councillors in Obingwa Local Government Council between 2016 to 2018 within 30 days from the date of this judgment, which shall in default attract a 10% interest per annum until fully liquidated. Judgment is entered accordingly, and I make no further orders as to cost.
As court pleases.
That is all.
Well done, my lord.
Thank you.
Well done, my lord.
A copy of the judgment shall be available for collection immediately after the proceedings today. Parties may apply for it. Yes, Simon.
Yes, my
Any
lord.
other case?
None for now, my lord. We are done for today.
All right. Any other information or announcements? No information or announcements.
Yes, my lord.
All right.
Thank you very much.
I wish you all the best.
Thank you, my lord.
The court shall rise.
Call.